A tabloid publishes a completely false story claiming you're a drug addict. If you're a regular person, you'll probably win a defamation lawsuit. If you're a celebrity, you'll probably lose. Welcome to First Amendment defamation law, where fame costs you legal protection. The Supreme Court created two different defamation standards, one for private people and one for public figures. And if you're famous, politically active, or otherwise in the public eye, you're basically screwed when people lie about you. For public officials and public figures, winning a defamation case requires proving actual malice. That doesn't mean the person hated you. It's a specific legal term meaning they either knew the statement was false or acted with reckless disregard for whether it was true. This standard comes from New York Times v. Sullivan, a 1964 case where Alabama officials sued the Times over a civil rights ad that contained minor factual errors. The Supreme Court said political criticism needs breathing room, even when it's wrong or democracy dies. Actual malice has two parts. First, the defendant knew the statement was false when they made it. This is almost impossible to prove unless you have smoking gun evidence like emails saying, "I know this is a lie, but I'm publishing it anyway." Second, reckless disregard for the truth. This means having serious doubts about whether something is true but publishing it anyway. Not just being careless or lazy. You need evidence that they had obvious reasons to investigate further but did not. And here's where it gets insane. Even completely false stories can be legally protected if you can't prove malice. A tabloid publishes a totally fabricated story about a celebrity's drug use. The story is 100% false and destroys their reputation. But if the tabloid claims they believe their source, the celebrity probably loses. The reckless disregard standard is brutally hard to meet. Courts want evidence that the defendant had serious doubts about the truth. So if a reporter gets information from a usually reliable source and publishes it without double checking and it turns out to be false, that's probably not reckless disregard. Public officials get the harshest treatment. Politicians can be called corrupt, incompetent, or criminal in the media, and unless they can prove the publisher knew it was false or acted recklessly, they have no legal recourse. This protects political debate, but makes politician reputations fair game. Public figures include celebrities, athletes, business leaders, and anyone who voluntarily enters public life. The theory is they chose to be in that spotlight, so they accepted the risk of false publicity. Private people didn't ask for attention, so they get more protection. But who counts as a public figure keeps expanding. Social media influencers, viral video stars, even people who just became temporarily famous can lose their defamation protections. Go viral for any reason and suddenly lies about you are harder to prosecute. The bottom line, actual malice makes it almost impossible for public figures to win defamation cases. The First Amendment prioritizes free speech over famous people's reputations, even when the speech is completely false. So remember, if you're going to lie about someone, make sure they're famous first. The law gives you much more protection when you're destroying a public figure's reputation.